everybody. This is Mrs. Clemens. Sadly, Mr. Marshall isn't with us today, but this still is U.S. History Flipped. Alright, so folks, today what we're going to talk about is the Warren Court. And if you can believe it, this guy right here, Earl Warren, handsome man that he is, he's Chief Justice in the 1950s and the 1960s of course, the Supreme Court, the prettiest court ever. And as you might remember, we talked about another Chief Justice early on in the class that we need to know for the Regents, and it's this lovely guy over here. Who is he? Who? John Marshall. It's John Marshall, the guy that we need to know for Marbury versus Madison, and McCulloch versus Maryland, and Gibbons versus Ogden, and Worcester versus Georgia. All of those fun and exciting cases. So these are the two Chief Justices that we need to know for the Regents. Today we're talking Earl Warren. All right. So he's an interesting guy. In that he's controversial, but he also does some really, really great things that make me like him a whole heck of a lot. One, he's the guy that's the Chief Justice for the case of Brown versus Board of Education. He is the Chief Justice for a case called Heart of Atlanta Motel versus the United States that upholds the Civil Rights Act of 1964, saying segregation's wrong. He's also the guy that brings us the Miranda rights, which we're going to be talking about. He's also the guy that's talking to us about, can we pray in school? And as a result, he's not always the most popular guy. And so, we actually have this billboard here that says, "Save our Republic, impeach Earl Warren." So, he had some people that didn't like him as much. Alright, so let's talk about this. By the way, our animation that's letting us know if we have to write is the wonderful gavel here. So Earl Warren, he was Chief Justice of the Supreme Court from 1953 till 1969. So that's a big chunk of time. It's a really important time because this is a major time of upheaval in the United States. He was known as an activist judge, and basically what that means is he's not a go-with-the-flow kind of guy that's sort of saying, oh, well, I'm just going to go based on how other people ruled and kind of keep things status quo. He was a guy that pushed boundaries. And so what I'm going to do is I'm going to kind of break them into three different parts. So the first part I'm going to look at is segregation cases. Now, we've talked about Brown versus Board of Education before, but this is the whole thing that said separate is inherently unequal, that there's no way that that schools can be equal, that anyone can have an equal experience if they're segregated. And what case did this reverse? Hang on, I can hear you. Yes, you're right, the Plessy versus Ferguson from the 1790s. So this is a big deal in 1954 that we have Brown versus Board of Education. As a matter of fact, he knew it was such a big deal that he actually made sure that it was a unanimous decision, so that when people were, because he knew people were going to criticize it, he said, I want everyone to know that the court is completely in agreement with this. And he actually, for any of the segregation cases, he made sure that it was a unanimous decision, that everyone agreed. So there you go. You see Linda Brown sitting there on the steps of the Supreme Court with her mom. Heart of Atlanta Motel. We talked about this too when we were talking about Lyndon Johnson. This upheld the Civil Rights Act of 1964, which said segregation in public places is unconstitutional, so no longer are we going to have colored waiting rooms or water fountains or any kind of public facilities. Another case, and this one I've actually been seeing more recently, Loving versus Virginia, and it's always an easy one for me to kind of remember because it's Loving. Basically what happened was you have this couple right here, and they got married. They actually got married outside of Virginia and then moved back to their home state of Virginia, and they got in big trouble. They were arrested in the middle of the night. It was really pretty horrible. And they fought it, went to the Supreme Court, and they said no, interracial marriages are absolutely allowed. And when we look at sort of the whole evolution of personal rights like this, obviously, we see today that gay marriage is something that's being talked a lot about. So Loving versus Virginia, this is one of the forerunners to some of those cases today. All right, our next group of cases, and this is also where a lot of, so obviously the segregation brings out, the segregationalists, the people that were in favor of segregation. These cases deal with the rights of the accused, and they also bring out people that are not happy, feeling that people that are accused of crimes, we need to fall on the side of the police. This is still pretty controversial. So the first one is Mapp versus Ohio. And so remember, folks, that these are the last names. So this is actually a Ms. Mapp. So basically what happened was here she is, she's at her house, and the police were, they thought that she was hiding somebody that might have been working to blow up something, and that also she might have a betting ring. And they came in, they didn't have a real search warrant, and what they did actually find was some pornographic materials, and that's what they charged her with. Well, you can't do that. You need to have a warrant. And so we get that from Mapp versus Ohio. Gideon versus Wainwright. This is a case where Mr. Gideon was getting up to some mischief in a pool hall, and this was in Florida. And so what they did was, he goes and he says, I can't afford an attorney. And Florida said, well, we only have to provide an attorney for certain cases. So sucks to be you. And so what ends up happening, he loses, he appeals, goes to the Supreme Court, and they said, now, anyone that can't afford an attorney must be provided with one. And so we have this quote here: the right of one charged with a crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. Escobedo versus Illinois. This says that you have the right to counsel during interrogations under the Sixth Amendment. In this case, Mr. Escobedo was suspected of killing his brother-in-law. They had a 14-hour interrogation. He had asked for a lawyer. His lawyer had been there asking to see him, and he was convicted, and that ended up going to the Supreme Court. And there's Mr. Escobedo. Miranda versus Arizona is the one that we kind of tend to know the most. So on the regions, sometimes they'll just do Miranda alone, or they'll be like, oh, what does Mapp, Escobedo, and Miranda, or Mapp, Gideon, and Miranda have in common? Sometimes they'll feel funny and they'll do Mapp, Gideon, Escobedo, but generally they try to link all of them, including Miranda. So what is the deal with this? It says statements made in response to interrogation are only admissible if the defendant was informed of the right to meet with an attorney, and against self-incrimination, the whole plead the fifth. So what happened was Mr. Miranda was suspected of kidnapping and raping an 18-year-old girl, and he signs this whole statement saying, yep, I did it, and he didn't know they had the right to an attorney, and yeah, so yes, it did get overturned. They had a new trial. He went back. In the end he got killed on the streets, so don't worry, he got his. I don't know. This is the Mapp versus Ohio. I like this. This is something called a glogster, which maybe I'll use more some other time. But so this is somebody's glogster talking about Mapp versus Ohio. So remember I said Mapp was a girl, and so if you want to pause this and read some of the things that it's actually talking about here, it's pretty neat. And then this is Miranda versus Arizona. Same thing. If you wanted to pause it and read some of that stuff there that's talking about Miranda versus Arizona, you could do that. All right, so our last couple cases dealing with civil liberties. We have Engel versus Vattel. And so what this said is that prayer in school is unconstitutional. So in this case, you had a child that was an atheist, and he thought that it was unfair that every morning that they had school prayer. And so they said, well, you could just, turn away or not do it. And he, his family said, well, that's making him feel ostracized. So it goes up to the Supreme Court, and they said, no, there's a separation of church and state, and no, in a public school, you can't have prayer. Now, can you in a private school? Absolutely, it's a different instance, but in a public school. And so you see all these protesters here, from Oregon and Florida and Georgia and West Virginia. It is actually still a controversial thing today, and you will see that some schools will still have prayer, not usually in the Northeast with us, but other states, and they'll just kind of ignore that ruling. This cartoon I've actually seen on the Regions. You might actually see it somewhere in our review materials. But yeah, this is, in talking about this, what do they expect us to do? Listen to the kids pray at home, and it's, he's upset about the Supreme Court ruling. The other case is Tinker versus Des Moines, and this is during the Vietnam War. And so in this case, you've got the two Tinker siblings, and so they're protesting the Vietnam War. And so we don't use this today, but they're wearing armbands that are black, and, they hook them around their arm. And the idea is it's a sign of mourning. And so they're mourning the deaths of people related to the Vietnam War. We don't do that today. Like if my grandfather died, I don't wear a black armband, but that's what people used to do. So they do that, they get in trouble, they get kicked out of school. And so this ends up going to the Supreme Court, and they said, you know what, you are allowed to wear them as long as you're not disrupting the school process. So if they were wearing like t-shirts with like dead Vietnamese children or something on it, that would be a different thing. And the same thing, if you want to pause this and look at this for a minute and kind of read some of those things, you can certainly do that. All right, so the results of the Warren Court. Increased civil rights. I should also say increased civil liberties as well. Things like the First Amendment, like we just saw in Tinker and in Engel. Increased rights for the accused, and definitely reform. All right, guys, I hope you'll join us again next time for our U.S. History Flipped.